Good day, everyone. Welcome to The Real Truth. I'm Tommy Spina. My guest today is Whitt Steineker. He is a partner with what used to be called Bradley Arant, Boat and Cummings, which is a large, what little lawyers that are in solo practice like me used to call silk stocking law firm. But they're not. They're good people. But they're just plain old Bradley now. So Whitt, welcome to our show.
Tommy, it's good to be here.
How'd you like that intro?
I'm looking at my socks now. I don't know what material this is, but it is not silk. So,
well, I also use the expression tassel loafered lawyers.
and no tassel. We're good. It's a new day.
Whitt is here to talk about, in a, I would say, conclusory way, what we've been talking about this season, which started with the director of the Alabama Medical Cannabis Commission, Mr. John McMillian, who I've been in touch with for 3 or 4 years now via Our Issues Birmingham and now the podcast. And we have focused this season of this podcast on what's about to become a reality. And so for our listeners, Whitt, can you sort of give us a short version? I know we joked in a private conversation about the enactment of that law becoming the Lawyers Relief Act for Montgomery County lawyers because so much litigation grew from it. But can you kind of walk us from where we were to where we are and how we got there and all the hurdles that we had to overcome to get there, if you can? I know what I just asked you would consume all 45 minutes of this program, but you can give me the short version.
Yeah, I'll try.
And I mean no offense to Bradley when I use expressions like that, by the way. So if I did offend you, it wasn't intended.
It will take a lot more than that.
Nor any of your buddies there that I like.
I'll have to take that up with them. But I would say, the law was enacted right at about 5 years ago. I think it'll be a couple of months, it'll be 5 years. And there was probably a year and a half of getting the commission set up, built out, getting the applications out. And then I think it was December 30th, 2022 when the applications were due. And everybody expected that, 3 or 4 months later, we would have licenses in hand and we'd be off to the races, and a certain number of newly issued license holders would be growing and processing and dispensing marijuana across the state.
Didn't happen that way.
It did not. And it really, the problem started almost immediately. They did award licenses, I believe in June of 23. Within a week, they had rescinded them, citing some scoring irregularities by the University of South Alabama, which they had outsourced the scoring of the applications to. About a month and a half later, they got back together, said, okay, we think we've got it under control. They issued another round. Litigation immediately commenced in the Circuit Court of Montgomery County, and really has been ongoing ever since in various iterations. It's also gone up to the Court of Civil Appeals a couple of times. And all of this has primarily been on what I would call administrative law bases. It hasn't been on
the law.
None of it's been on people talking about in court about how they would grow or sell marijuana, or why they would be better than someone else, or why someone else was inadequate. It was all, did you name the right party when you filed this action? Was it timely? Was it ripe or justiciable?
Was the form filled out properly?
Those types of things, yeah.
Well, we had many more applicants than we had slots for licensees.
Yes.
So
I think it was something like just under 100 people applied to receive an application. And then there were probably 50 or 60 who actually submitted an application back in December of 2022.
When you're referring to an application, throughout this season, we have interviewed and tried to make people aware of the various entities and types of licenses that were issued for what purpose, like the laboratory guy, the processing guy, the cultivating guy. Are you referring to, quote, the integrated license, of which there are only 5 out there available?
The numbers I just used were for all of the different license categories.
Okay.
And so I think my best recollection of the integrated category, and that is based on the last time the commission voted on all of the license types, was back in December of 23. And at that point, I think there were just under 30 applicants for the integrated facility license.
And so that people know, in case they've forgotten, an integrated license encompasses the ability to do all of the things that the individual licenses provide for. In other words, an integrated licensee can cultivate, process, use their own laboratory, use their own transporter, use their own dispensary to get the product from seed to sell, as it has been referred to, all of which occurs within the state of Alabama.
Yeah, they have to use a state licensed lab and state licensed delivery transporter. But
so they don't do their own transporting.
Right. They'll use one of the ones that has been
approved.
Licensed by the state. But otherwise, in terms of the cultivation, the processing, the dispensing, yes, it'll be fully integrated.
Yeah. So that's what it is. So where are we now? That's the history.
Yeah.
Are we through litigating?
No. So we have cultivation licenses in hand, so people can cultivate marijuana in Alabama right now.
We know from past shows that Antoine is singing to his plants as we speak.
Right. And we have processing licenses have been issued, and there are 4 of those.
We have talked to one of those, and they're gearing up, but they can't really.
They can't receive it until it's been tested and delivered to them by a secure transporter.
Yeah.
And then even if they could, they don't have anybody they're about to have people who can dispense it, because we have 3 of the 4 dispensing licenses in hand. There is ongoing litigation about the 4th between 2 parties. One who the commission recommended receive the license and actually attempted to issue, or actually the commission said it would not issue that license, and to give the person who came in 5th, the applicant who came in 5th, an opportunity to appeal to Montgomery County Circuit Court. They availed themselves of that opportunity. So there is ongoing litigation in Montgomery County right now to decide who's going to get the 4th of 4 dispensary licenses.
But the others can go forward.
Yes, which means that...
And we have one webpage I know that's been launched, although it's not active or interactive, I might say. It has been launched.
Yes. And then you have the...
Drawing the blank on the name of it. Cali, something like that. Well, I'll get it.
Yeah, it's CCS of Alabama.
Okay.
I think, as far as I know, they're on track to, provided that they can get product processed and sent over to them. I mean, I think they're ready to go.
They are ready to go.
In sort of weeks, not months situation.
Callies, CALLIE', which happens to be my daughter's middle name.
There you go.
She'll be proud.
And they'll appreciate the free
podcast.
Advertising.
Emma, they named this dispensary after you.
So that brings us to the integrated facility litigation. And that has really heated up, and that is currently before an administrative law judge who is Justice Harwood, formerly of the Supreme Court.
Yeah. Out of Tuscaloosa.
Right. And I think at last count, and I'll disclose that I represent a party who's involved in that litigation. But at last count, I believe there were 15 applicants who were actively participating in that proceeding.
For those 5 integrated licenses?
Yes.
Well,
And
I will go ahead and disclose that I have a familial interest in one of the licensees.
Got it.
No monetary interest, but I have family that lives in Florida. Let's just say it that way.
that does narrow it down, although it does not rule out everybody. Justice Harwood has said that there will be an approximately 3-week, essentially bench trial, where each of the applicants will basically have their own day to present their case to the court via live witnesses. They can have experts if they wish. The other parties have an allotted time to cross-examine. Each party can cross-examine, at the end of a up to 6-hour presentation put on. So
wow,
we could have some very long trial days, and if all 15 go, theoretically, that right there gets you to 3 weeks.
So does that mean that it will boil down to Judge Harwood making the call on which 5 out of 15 get the licenses?
I would say it's
subject to the approval of the commission.
And the last part is critically legally, but it is
what I just said.
Yes, because it is remarkable in retrospect that after all of this, and after all the number of eyes that have looked at these applications and the whole process, that 15 days and one guy in Tuscaloosa, admittedly a very well respected judge,
exceptionally so,
right. And I'm not suggesting that anyone else would be more capable of doing it, but after all of that, he's going to have a huge say, because he will ultimately, if the previous administrative law proceedings in the other categories are a guide, he will ultimately recommend who the 5 most suitable applicants are in his mind. And suitability is the word used in the statute. So he'll determine the 5 most suitable. He'll write that up, and there'll be a written order.
And keep in mind that this is administrative. For those out there who don't understand the distinction, when we lawyers use administrative procedures as opposed to judicial proceedings, one is more regulatory, I would say, based, and the other is more rule of law based, if that's a way to say that makes sense to somebody that's not familiar with those terms.
Yeah.
Sort of like your driver's license. ALEA controls that. That's administrative. That's not based on law. They decide who has the privilege, not the right, to drive a vehicle. And what you're saying is Judge Harwood's going to make a recommendation to the full commission of who has the privilege to possess an integrated license. Would that be a good way to summarize that?
That is a good way to summarize it. And another way to think about it that is sort of interesting to me is the commission voted on 5 awardees back in December of 2023. Justice Harwood is now hearing administrative appeal. It's called an investigative hearing in this context, but it's an administrative appeal where he will then say who he thinks is the most suitable 5. And then he'll send it back to that same body and say, having conducted a presumably very thorough examination of all the evidence, and noting the passage of time between when they voted and how circumstances may have changed with these applicants in the last few years, 2.5 years, it very well may be that there's a good reason for him to say, at this point, I think the 5 most suitable are these 5. And then the commission could adopt that in full, that recommendation in full, and issue the licenses to those 5. Or it could reject it in total and say, no, we like the way we did it, or it could go a different way.
Either way it went, there's still a door with anybody that has a filing fee to walk through to appeal whichever decision, wherever the coin Falls.
I mean, I would think the day
And
after the commission votes, there'll be a motion for a TRO in Montgomery County.
Shakespeare said it first. If it weren't for lawyers, we wouldn't need lawyers. No, that was Steve Salter that said that, my good friend.
He was paraphrasing Shakespeare.
So, in light and in spite of what you've just described, we are still in a position for places like Callie's to be open for business as soon as they can get product.
Yeah.
And get it onto their shelf.
We got to get patient certified.
We have over 20 doctors now
Right.
that have been certified. As a matter of fact, we have an interview coming up with Dr. Whitt, who had me absolutely befuddled with chemistry and cannabinoids and flavonoids and terpenes and the incredibly large number of those items that grow from this one single hemp plant. So I hope you tune in for that episode, but be prepared to have to concentrate.
Should probably bring a dictionary, but you seem to have the lingo down pretty well.
I do now.
Yeah, it took me a while to get up just the pronunciation on some of this stuff.
Yeah.
But yeah, it is
Yeah,
amazing.
I couldn't say cannabinoid for years.
Look at you go. I was last night. But then it's cannabidiol, which is for CBD, which is
He
always
used
very
that
confusing
word.
because it's a cannabinoid. I call it CBD, but
But that's I can't even say it right now.
cannabidiol.
Diol.
Yeah. Why wouldn't it be cannabidiol? I don't know. But to the point about all of the cannabinoids and the properties of the plant, I think that one of the functions of having really fairly new access to marijuana after 50 years of prohibition at the federal level, it's remarkable how much we're learning about the scientific properties, and some of the benefits are almost certainly overstated, but a lot of the benefits are probably understated, and a lot of things we just had no idea. Like, we didn't know a lot of these cannabinoids existed 3 years ago, 5 years ago.
Well, I do notice that the legislation requires that a certain amount of the money generated either from the taxes to the state be reinvested in research and development.
Yeah, I think it's the commission uses the taxes to pay for itself, and then if there's anything above that, it keeps 10%. And then 60% to the general fund and 30% goes to research and development.
Well, it's an ongoing process. I know you use the word marijuana. I've trained myself to use cannabis because it seems to have better marketing to the general public who may be opposed and think that what's about to happen in Alabama is what has happened in places like California, Nevada, Colorado. We are not going to be in that universe, and I don't think people really have a firm grasp about the fact that the word medicine is important in this dynamic, and the word patient is also important in this dynamic of us being in the position to even have this conversation to begin with, or we would never be there.
I think that's exactly right. I'll say this. I try to use marijuana, hemp, and cannabis very carefully because they're all marijuana and hemp are two legally distinct terms, but they're both part of the cannabis plant. So
or the hemp plant.
Yeah, right. And hemp is a federally defined legal term of less than 0.3% delta 9 THC. And marijuana would be basically cannabis plant that isn't hemp. So the rest would be federally described as marijuana. And and I know you've talked to several other guests about the about Alabama's hemp program and the changes that has happened there, and then what's happening in the medical cannabis program. And to your point there, anyone who was looking at Alabama as sort of a pot tourism destination, I think would be sorely disappointed. I mean, this is about as close to a pure medical program as you're going to get. And I think it's important that we realize that the regulators are going to be treating this like medicine. And it's not exactly like medicine because you don't get a prescription and you don't go to a pharmacy, but it's about as close as most states have been able to muster. And, there's no flower. People aren't going to be walking down the street smoking it, or certainly not doing that legally.
There's no oil.
Right. I mean, it's going to be taken.
No vaping, no edibles.
It'll be ingested
one
in
gelatin.
The way. Right. One
They don't
single
even
flavored.
They don't even call it a gummy.
It's a gelatinous cuboid.
Say it again.
Gelatinous cuboid.
Cuboid. There's those words again. Cannabinoid cuboid.
And so, basically the methods of administration, I mean, the way you take it will be similar to the way you take traditional medicine. And I think the point you were making is, if it wasn't that way, then it wouldn't have stood a chance in the legislature. If it felt a different way, the law wouldn't have passed.
I've asked others this, but you would be a better person to speak to this issue. You don't foresee there being any chance where, if we have a change of administration, where all of this hard work for the last 5 years that the commission has put in, I know you can't predict the future, but the word repealed comes into my brain because I'm a lawyer. That would really cause a lot of people heartburn. The people that I've talked to before have indicated that's not going to happen because of the relief it gives particular patients, especially seizure patients that suffer from seizures, and especially children with seizures that benefit from medical cannabis. I guess anything can happen, but
yeah, I don't think there'll be a repeal. I think look at PAST, and it passed with a sizable margin a few years ago. I think there's enough anecdotal experience in the legislature, frankly, a number of whom are older and who have friends and family members who have think they've benefited from even either they've gotten marijuana from other states or were in other states and tried it and it helped them with some issue they had,
which was non-specific to what the doctor who gave them the card recommended for them. As a matter of fact, Dr. Whitt told me that once a patient acquired whatever they acquired, he wanted to follow up with them to see that what he had in mind to treat their specific ailment was what they had been provided for at the dispensary. Now, Vince Shalacy, who's also with a very high-profile big firm, Maynard Nexon, and I speak of these two firms respectfully. I want you to know that. I'm not giving any lip service to them being bad people. They're very smart people. As a matter of fact, the lawyers that I've worked with in both of those firms and a few others are incredibly smart people. The fact that you're on the leading edge of this speaks to not only the validity of what's going on in our legislature and getting this product out to the community, but the credibility of the commission, of the legislation, of everybody in the process. So to have the Bradleys and the Maynards of the world involved gives credibility to the entire process of what we're trying to accomplish here. So I say that with respect when I poke at y'all.
Yeah, I do appreciate you saying that. I think you're right. And to your point about, even though I don't think there would be a repeal, I do think that it is the responsibility of the industry and of the licensees and of the commission and and the doctors who are certified, and to some extent even to the individual patients to take seriously the duties they have as stakeholders in the industry, because I could absolutely see there being a some sort of peeling away of some of the qualified medical conditions. The legislature could make it a little more difficult to
Well, they
obtain.
already did,
Right,
from the original president.
and so they could. I think the natural inclination would be for there to ultimately be a loosening over time as the program shows that it can be viable and credible, and there's some other qualifying conditions maybe that should be added, or even something like flower, which I don't think it's currently being considered, but if history is a guide, that'll in other states, that's something that almost certainly will be brought up to the legislature at some point in the next few years, I think the legislature will be looking at all of those proposals, informed by what the story is on the ground with how people are accessing the product. Is everybody doing what they're supposed to be doing? Are there a bunch of recalls and a bunch of diversions and it's finding out that stuff's on the black market? I mean, those would all be very problematic and could change the circumstances. But I really think that I know a lot of the people who've received licenses so far. I think the state has done a very good job of getting the good, credible people in who are capitalized and who don't have to cut corners, and should be able to get this process up and running and have a chance at success.
Well, your comments raised two things I wanted to ask you about. You mentioned initially other states, so I'll start there. I trust you're familiar with like Illinois, for example. I think it's medical. I think. No.
They have a medical program, sure.
They do. I know DC is I think got some goofy gift.
The gifting statute.
It's comical.
It's changing now, but yeah, it used to be that you could you could go in and
get a cup of tea.
Yeah, they'll sell you a T-shirt for $60, and then they'll give you the marijuana, which is
hypocritical.
Yeah, and illustrative of frankly, I think I think it's remarkable that you have a Schedule I substance at the federal level, which by definition means it has no currently accepted medical use, and yet north of 40 states have programs for its medical use. I mean, I don't know how those two things exist simultaneously. So the whole, almost every turn when you deal with this from a legal perspective, you realize that there are pieces that just irreconcilably do not fit.
Yeah. Well, you must be looking at my notes. So where are we with respect to other states in terms of, if you had to make a comparison, more stringent, more in line with Mississippi? Mississippi had a false start. Yeah. Dr. Whitt talked about that a little bit. He's involved in that commission as well, or that legislation or whatever it is he does for Alabama. He also does it in Mississippi. But do we track along with most medical cannabis states pretty closely?
Yeah, I think we're probably on the more conservative side.
Yeah, that wouldn't surprise me.
The flower is pretty significant. And it made it, I think, I had a number of conversations with people who were considering submitting applications, way back when, 4 years ago. And
well, that's what everybody thought. My clientele,
and
they're ready to open.
Right.
I said, hold on, it's not going to work like that.
Right. And I think there's some people that when they saw there wasn't going to be flower, people who had the experience in other states and sort of were looking at the numbers and their sales and what percentage of their sales were flower, thought that Alabama very well may become a profitable, good market to invest in, but from an investment perspective, not from a patient care perspective, but from an investment perspective, I think they were happy to wait on the sidelines and see if somebody could get something going. And then if somebody ultimately established a nice operation, maybe the program loosened up a little bit, then they'd come in and maybe try to, enter into some sort of investment or acquisition.
The other note I'd written when you were talking about Judge Harwood making the decision to send who he thinks are the appropriate 5, the chosen 5, we shall call that. There has to be self-regulation. Is that built into the legislation as well? Or is that just something that, like lawyers, we know we're supposed to do right, even though there are some lawyers that don't do right?
Yeah, I think it's more like that actually. But I will tell you, I mean, because I represent a number of people in different license categories, I've been very impressed by the conscious efforts that have been made, both by people within the same category to try to make sure that they're all not doing it the same, right? They're not trying to walk themselves into some sort of antitrust problem, but making sure that,
sort of like Live Nation.
Yeah, they definitely do not want that problem.
I still don't understand how that's a jury trial, but I asked somebody the other day and they explained it to me, but we digress. Back to cannabis.
Right. Right. So I would love to talk about Live Nation another time. I think it's largely, so they're obviously regulated by the Medical Cannabis Commission, and there are extensive regulations about that. But I think there is a sense of sort of self-policing, not so much in a snitch way yet. I mean, that certainly could develop, but I think a little bit more in a constructive, proactive way. And I suspect what you'll see ultimately are associations that might even be at the license type level. There could be a processors association, there could be a cultivator association, because they all have slightly different interests.
Oh yeah.
But then there could overlapping, sort of concentric circles where there's an independent license association that just had the cultivators only, the processors only, and the dispensaries only, versus maybe the integrateds all get together and have theirs. I mean, you could see how, and then maybe there's one that covers everything, because everybody's got slightly different interests, and it would be hard for one association to cover everybody. There's been several attempts to start an association, several associations up until now, and I think they've struggled to some extent, because I think you have to get to where you know who the players are before you can form an association. Because right now you had yourself in the situation where some of the members were awardees who were trying to defend their award in litigation against people who were other members of the same association who were not awarded licenses, who were trying to knock them out. Right. And so it's tough to have a cohesive association when you've got dues-paying members.
Limited numbers of members of the core group that are licensed to do the service that they were licensed to provide.
Right. But if everybody has a license, then that problem sort of goes away.
You mentioned one other thing that I'm going to go into, which is the insane Schedule 1 classification of cannabis that our unitary executive has announced that he would move to a Schedule 3. I don't know how that happens from a regulatory way. I suppose that comes from the FDA, maybe?
It actually comes from the Department of Justice. The Attorney General would have to make
Which is in great shape these days.
The Attorney General...
This is a podcast, Whitt. You can say anything you want.
I could say anything I want. I'm going to exercise...
I already had that conversation with John Archibald about fake news and there being no guardrails. So...
I'm going to exercise...
Remember, the name of my show is The Real Truth.
Right. I'm going to follow the instructions that I'm sure you often give to your clients, and I'm going to remain silent on that one. But
you didn't see my chapstick, and did you get one?
I didn't want I saw it and I was intrigued, but
Did you read it?
I'll grab it on the way out.
Did you read the logo? You got some free advice on there.
I'm really embarrassed to say it. I couldn't. I didn't have my glasses on. I couldn't read it.
It says,
what's it say?
keep your lips sealed.
That's very good. The Schedule 1 thing is wild, particularly since cocaine is Schedule 2, and I don't think there are many people who, if we had to start from scratch and where we list marijuana, you put marijuana in Schedule 1, but for it to be rescheduled, it'll take the Attorney General, who has already received recommendations, this was during the Biden administration, from HHS and FDA about and they recommended essentially that it be in Schedule 3, but now it's just up to the Attorney General, who currently is Pam Bondi.
Who's got her hands full with other things right now.
Yeah.
Probably not a priority.
I don't know when this will air, but I think that will be true no matter when this airs, is that she will have her hands full with things that frankly are, I think, seen as more important. Yeah. And, maybe that's true.
So in talking we talked about Schedule 1 to Schedule 3, which is no medical purpose, to there is a medical purpose, which brings into question why we call a dispensary when, in my mind, and I know in at least Callie's mind, that's the dispensary that I talked about to begin with. And I talked to Dr. Boyette about this. Dr. Boyette's not really writing a prescription, but the dispensary is kind of akin to a pharmacy, where they are dispensing, but they're dispensing medicine to a person who has been given a medical marijuana card by a physician who has taken a course to identify specifically with Dr. Boyette what combination of cannabinoids, which includes THC, Delta-9, along with the gazillion other versions of cannabinoids that come out of this little plant, would liken a dispensary to a pharmacy, in my mind.
I mean, I think they're very analogous, and I think it's probably the federal illegality is really the only reason. Maybe it's certainly the primary, and maybe the only real reason that we don't just treat it that way. The doctor can't prescribe a Schedule 1 substance, and if he did, he would be putting his DEA license at risk.
Yeah, he made that clear to me.
So,
okay. I wasn't thinking in those terms.
Right, and I didn't until I first got into this, and it makes all the sense in the world, I guess, if you're trying to square peg round hole things and say, okay, we're gonna let people do this thing, but some of the players can't do certain things. So what are we going to say? We're going to say he's not prescribing anything. He's just going to certify that they have a qualifying medical condition. He's going to say, yes, this person has Crohn's disease. This person has PTSD. And then by virtue of that certification, they'll receive a card from the state that they can then take into a dispensary, which I think the good dispensaries, and the ones that I'm talking to, and I think Callie's is a great example of this, are going to want to have almost a pharmacy-like experience, certainly in terms of the ability of the patients to feel like they're in a safe, regulated place with professionals who know about the products that they are dispensing, and they can talk with some education about the benefits of one product over another, or maybe one, should you use this from a tincture, or would this be better, as one of these peach gelatinous cuboids? Yes. And so in that sense,
it's comical. I can't help but snicker.
Yeah. I mean, in that sense, it's almost identical to the traditional sort of prescription and then pharmacy.
But we have a lozenge, don't we? Don't we allow for a lozenge?
Yes.
A tincture, a lozenge, ointment as a topical.
Suppository.
I thought we had a suppository.
That's right.
Fascinating. We have a pill?
Yes.
Oh,
Well, and one other thing about rescheduling that I think is far from clear is what implication there will be on a state-run program if there is rescheduling at the federal level. And so what I mean there is, let's say the Attorney General comes out and says, okay, now it's going to be regulated as a Schedule III substance. Well, the reality is it wasn't being regulated as a Schedule I substance. I mean, it was classified as Schedule I, but
there was no regulation.
and for years, it had been both the formal and informal policy of the Department of Justice not to prosecute people who were operating within the confines of a state legal program. If they move it to Schedule III, there will certainly be tax benefits to operators. That is one thing that is clear. But if they move to 3 and then continue to treat it like they treated it with Schedule I, then okay, great, they get tax benefits. There's it probably frees up the banking system a little more than it is right now. But these programs, state programs, all stay in place. I do think there's a scenario, and this would be extremely perverse, and it would be counter to the goals of what I think all the people who are advocating for rescheduling want, where the federal government says, okay, well, if you're a Schedule III drug, then if you want to have a drug approved by the FDA, then you go develop one for a specific dose for a specific indication, and you submit it, you run clinical trials. You have to get it approved by the FDA. This is a process that can take years and tens of or hundreds of millions of dollars. And then somebody can, if it's approved, then somebody can go to a doctor. The doctor can prescribe them for that indication, a certain dose, and they can go get a certain amount from a pharmacy. I don't think there's not many current state operators who would be able to do that. And that would be sort of, I think, the nightmare situation for people who've been...
The conflict between federal and state law,
I think
essentially.
I think the people, if the federal government said it's Schedule III and we're going to treat it like a Schedule III drug, like we treat all the other Schedule III drugs, then I think that would be very bad for people who've been running state licensed operations for decades.
Yeah.
And so
in some of the recreational
yeah, and it would have practically it would mean that there would be no access to marijuana for years while that played out. And that's not what I think anybody wants who has an interest in rescheduling. There's plenty of people who don't want there to be access to marijuana, but of the people who would be deciding if it should be rescheduled or not, and then the people who would have to say, do we really want to spend federal dollars on this? We weren't prosecuting it when it was Schedule I. Why would we prosecute it
as
more as 3?
Now that it's medicine.
Right.
Well, again, being a criminal defense lawyer and essentially a sole practitioner, I've been thinking about how this will play out with law enforcement on the local level when that person, they're not going to smell it. So, sometimes the odor of marijuana is the probable cause
Right.
developer, at least the reasonable suspicion that leads to the probable cause, to the famous words, would you step out of the car?
Right. Yeah.
It all begins with a broken tail light.
Yep.
So how I don't know how this is going to play out in my world. I have a person who's charged in some community with the possession of a controlled substance. He has a card. Right now, it would be a Schedule I controlled substance in a form that the Alabama Medical Commission has authorized him via a doctor to possess. And I don't know how that plays out in that moment on the side of the road when law enforcement has to get educated on how far they can go with whatever it is that brings them to that person's pocket who finds the tincture or the cuboid.
Right.
Uh,
There are a lot. I will say there are some provisions of the statute in Alabama allowing for medical cannabis that make clear what like employees, for example, can be terminated if they use medical cannabis. But being on the medical cannabis registry is not, for example, itself a probable cause or reasonable suspicion.
Is that a public access document, the medical cannabis registry?
I'm almost certain that it's not, although the
PM.
ALEA certainly can access it.
Yeah.
And it makes policing a much more difficult task, particularly given that we don't currently have the science to test whether somebody's actually impaired. So they could have up to 70 daily doses of marijuana in their car, and that wouldn't necessarily be evidence of anything. It would be evidence that they could be selling marijuana, or it could be they're coming home from the dispensary with their perfectly legal allotment. And so, I suspect this is, maybe it gives you more things to argue, but it's probably also very frustrating, I'm sure, based on your sort of experiences with clients in the past. It's frustrating to hear that, well, we're just going to have to do better policing because, we'll see if that happens.
I don't know.
Yeah.
I've told you when you came in, I've been having a difficult time getting a transporter in here, and we're going to wrap up in just a couple of minutes. But I wonder if the transporters are a little bit schizoid. If there's a transporter out there that's listening, if you'll just call me, I'll be happy to have you in here to talk about what all you've been through to get your transport license. But I can't seem to get one to call me back. So anybody that's listening is welcome to get in touch with me and come visit with me. But I thought a reason why they might be a little hesitant is the word security. Because here's a truck going down the road. I'm sure it's not like marked on the side, cannabinoid central.
Probably not, yeah.
But, security is a big deal when it comes to the dispensary,
Sure.
to the cultivator.
Sure.
Now, the processor would be something that would be concerned about
Sure.
security.
I mean, the processors got starts with raw product that people
Biomass, I've learned to call it. I've got a new language.
You're in it. And then they have, at some point in the process, they'll have a tray of gummies that if somebody came in, they could get, 6,000 gummies, in 30 seconds. So, I mean, they're absolutely vulnerable.
Yeah. And so I thought that might be the hesitancy, but I guess it's at every level except maybe the laboratory level, because I learned that the laboratory is not taking the entire plant from the cultivator. They're just taking a piece of the plant and reporting back to the cultivator what they have, right, what they've created, depending on the song that was played to the plant. Right. I want to thank you for being with us today, and I want to give a shout out to Bradley for being a very good law firm. And I really feel badly about starting my show calling what used to be used as kind of a joke. So
I assure you that I've been called worse already today, and we'll be again. So
y'all are a lot less civil than we criminal lawyers. And I don't mean that y'all being Bradley. I mean, civil lawyers seem to be not so civil. And divorce lawyers seem to be the absolute worst in civility toward one another, I'm talking about.
Sure.
It's just an ugly scene. So I thank you so much for your time and your knowledge. And it may come a day when we get up and running that we might want to have you back to check in if I do an episode or a season on where are we now 3 years from now. I don't know where I will be 3 years from now. So thanks for being with us, and thanks for giving us the real truth.
It's a pleasure. Thanks, Tommy.
Thank you for joining me today on The Real Truth. My name is Tommy Spina. I hope you enjoyed today's conversation. I hope you will follow or subscribe to my podcast and listen in to the next episode. If you found it valuable, please take a moment to rate it and review it. It helps us to reach more listeners that care about the issues that matter. Share it with a friend. Stay engaged and remember, the truth matters. I'll see you next time.